let's go off to the main topic now. I've got a few things to say before you tell the truth, all right?
Before I tell the truth.
Can I say the AMIU, which is the meat industry union, is not a tough union. In fact, if I look across the country, and we act across the country for meat processing, outside of South Australia, there's not a lot of representation of the union because that's its stronghold. And even then, they're struggling terribly to get enterprise agreements up. So JB, Tees, they're very big, and the union's got into them. But one of the things you don't do with a union is poke it with a stick. So you don't do stupid things like stand down delegates for having slightly too long meetings. And
it was for slightly too long smoko break.
Make a smoko break.
It was more than the 8 minutes.
Well, no, it was 8 minutes, but they were having a meeting. So an authorised meeting in the 8 minutes.
Yeah, but that's what they...
I know. But as Nina goes through the facts, what you'll see is an organisation who just created their own problem. Unions, particularly weaker unions in large country-based areas, don't have leverage, okay? And if you're reasonable with them, they don't want to have a fight because they know in most fights, a whole group of people will say, no, we don't like unions. And this union wanted greater presentation. Smoko rooms, notice boards. All Tees had to do was sit down with the organiser and get the organiser in with the delegate and say, we recognise you're right. We're happy for you to put a notice board up in each smoko room, and if once a month you want to get up and address the guys for 10 minutes, cool by us. He would have gone away. But Nina, tell the story.
Yeah, so they've brought a general protections claim on the basis of discrimination for engaging in industrial activity and also for breach of delegates' rights. But it's very convoluted, but they brought it all the way back to when they first issued a notice for reasonable communication. Immediately after, Tees said, you took too long a smoko break, so we are standing you down. And they issued them with show cause letter as well.
So can I just give an example? So every enterprise agreement time, unionised sites say, can we have meetings? And we always send them a letter and said, the meeting will be between this time and this time. If it goes over, it will not be approved. You won't be paid for it. They always go over it. We always know that's going to happen because that's industrial life. So you'd leave it alone. You'd go and talk to them and say, look, we won't approve any other meetings if you won't comply. That's what we always do. It's the next increasing of pressure on it. They stood him down for going over the smoko break. Not only that, they gave him a show cause letter, which after getting some legal advice, clearly
they withdrew.
And the word dumb was tattooed on every manager's forehead for a week afterwards. No, it's not true. That bit I made up.
So things kind of settled down for a bit, but then the union came back and asked for more things. So under the Delegates' Rights, they're allowed to ask for reasonable communication with members and potential members and access to workplace facilities. So they said, we want notice boards, and they said you can have one notice board to put union stuff on. Then they wrote and said, we want to be part of inductions with staff, and we want to stand up in the lunchroom and be able to talk to members about union issues. And also we want all 5 notice boards again. Tees didn't react kindly to that and kept saying no.
Can I just say, so when you're dealing with a union, that's called ambit, okay? So whenever you negotiate with a union, they'll always ask for 10% rise a year. They'll ask for a whole body of things that they want. The dumb person says no. The smart person says, can we have a conversation? And a whole lot of the ambit just falls away.
Yeah, I think it could have been done through a negotiation. But they kind of just dug in their heels and then turned around and said, hey, you're breaching lawful and reasonable directions because you're using a different channel to raise your issues. You can only use your delegate's email. If you don't do that, we're going to discipline you.
See, that's it. Just keep poking the bear.
The union obviously brought the case, and they're now asking the federal court to make declarations that essentially the delegates' rights will extend to participating in all inductions, that they can discuss union issues in lunchrooms and a whole bunch of other stuff.
But Nina, I mean, the part that bothers me about this is that none of the rest of it bothers me. The part that bothers me is the induction part. Okay.
Yeah, but I also feel like standing up in lunchrooms, subjecting it to people who don't want to involve is also...
all that could have been dealt with, though. Does that make sense? Yeah. But the issue here is it would be lovely if all judges came from the same political party, the same background, but now Tees have thrown themselves in the middle of a ring where they don't know who they're boxing.
Yeah.
And they may be boxing someone who's easy to beat up, or they may be boxing Muhammad Ali. They don't know who they're fighting.
Yeah.
And to put such an issue, such an important issue around delegate rights at risk, where they may never appeal it, so we'll have a piece of law sitting out there.
That will affect everyone.
That will affect everyone. It's just incredibly disappointing, and the process was so incredibly dumb to get there. And you can't help thinking there's been some incredibly poor advice which has been supporting a narrative we need to beat the union up.
Yeah.
And the answer is anyone who tries to beat a union up brings on a fight, because that's actually what unions do. They're better at fighting than the rest of us. That's what they do for a living.
Yeah.
What they're not good at doing is winning people's heart and souls if you're generous, simple and clear, and you run a communication argument with your trusted employees. You say to them, we don't want you in your lunchroom. They could have done all that stuff, but they didn't. They picked and picked and picked and prodded and prodded and prodded. Now they've got an application which in some parts they shouldn't win, in some parts they're going to lose without a doubt. All they had to do is shut up. And if they lose, if they win, so here they have their great victory, they win, they come and have their first victory. Do you think the union's going to leave it alone at that?
No.
The union will then appeal because they have no fear of appealing. And then we've got 3 years more of uncertainty sitting around this case. The whole problem with new bits of legislation is you don't pick fights you're not going to definitely win. That's the rule.
I think this case can be very closely watched by everyone.
Yeah, well, certainly by us anyway, and I'm sorry for tease if there's anyone there who cared for me once and probably don't anymore. Sorry about picking on you. Why don't we go to the case study?
Yep. So Naomi had worked with City Work, a large construction business, for over 20 years. She was a building estimator and trusted. Over the past 2 years, her eldest son, now 17, had struggled at school with his mental health. She was aware that his dabbling with serious drugs had become significant as he was stealing from her and her husband. She felt lost and was struggling to concentrate at work. Her new boss, Sarah, was a complex soul, awkward, abrupt, and lacking empathy. Naomi had told her that she was struggling with her son and received the response, "Yeah, kids can be tough." Oh my gosh. Sarah regularly made unhelpful comments to Naomi and others about their work. It was small point scoring, micromanaging type of stuff. But Naomi's resilience was wearing thin. She was a strong woman and kept turning up. Her work remained of a high standard, but the rest of her life was collapsing around her. Her sleep was shot. She found herself sobbing in the bathroom at work and had become very isolated. Others noticed and told Sarah. Sarah would respond with comments like she needs to get herself together and needs to leave her problems at home. Naomi heard what had been said and was deeply hurt. Sarah approached her for an update on a project. Jokingly, she said later, she asked Naomi, "You are looking pretty knocked around. Miss your hairdresser appointment." Wow, there's no emotional intelligence with this one. Naomi looked at her, broke into tears and ran out. She went to a nearby cafe, called her husband Tears and asked him to collect her. She sculled 2 bourbon and cokes. Sarah walked past, saw that she was drinking and said, "What do you think you're doing? This is work time and drinking is prohibited. Go home and let's talk about it in the morning." Naomi, now freed up by a little alcohol, gave it to her with both barrels in public in front of many people. She received a show cause letter by email and a direction to attend a 10 a.m. meeting, failing which a decision would be made. Naomi didn't attend and was summarily dismissed.
So the question, does Naomi have a strong unfair dismissal claim?
Yeah.
Yeah, lay down, Miss Air.
Like, definitely.
Can I just say one of the reasons?
It's going to come down to harshness. Although there would be a valid reason with like the abuse and the drinking and stuff, it's going to go overridden with the fairness and harshness.
Yeah. Can I just say the reason I wrote this story is I like writing stories, but one of the things that people miss is that when you would turn up in front of a tribunal or court, what you did as an employer is never lost. So the tribunal member or judge will be sitting there listening and going, "You did what? Yeah. You said what?" And it poisons, it pollutes the case. Yeah. And you can never get away from it. Yeah. Once it's heard, it's there. And the moment the judge or the tribunal member heard what Sarah said, it was all over. Anyway, would you have a strong workers' comp claim? Totally. Yeah, that's a winner too.
Was Sarah a bully, and what action could have Naomi taken to stop it?
What do you reckon?
Yeah, she was a bully.
Yeah, no,
You don't remember? It's not like it's an objective
I'm not disagreeing.
test.
I wrote it. Yeah.
So I think sometimes people think about, you have to have an intention to hurt someone, and that's not a factor in it. It's an objective test. So it's whether a reasonable person in that situation would think that it was unreasonable, repetitive behaviour. And I think by our reactions of us scoffing throughout reading
hurt, humiliated,
it
or
was
intimidated.
clear.
Quite clearly, she's been
Yeah.
humiliated and hurt.
Yeah.
And did it affect her safety at work? Yes, it did.
It harmed her.
Yeah. So
Yeah.
there you go. What action could she could have brought a stop bullying order?
Yeah, or yes. I think she also could have reported it and it could have been investigated and dealt with.
And she could have brought a general protections claim even though she was employed.
Yeah. I mean, they're not as effective though.
Not as effective, but they scare people. I just saying, when we get them through when someone's employed, you and I both go, oh, what are we going to do to get out of this? Was there a breach of safety law?
Yeah, undoubtedly.
Absolutely, yeah. So the section, in Victoria, section 2122, everyone else was, did they do everything reasonably practical to provide a safe place work? So was there hazard? Yes. Sarah?
Yeah, was aware of it and she ignored it and she exacerbated it.
So definitely breach of reasoning practice, definite breach of safety at work, definite failure to monitor health.
Yeah.
So you got.
I think she was reckless as well.
Yeah, she was close to reckless. Yeah. Do you think she'd be charged?
Under reckless?
Yeah.
Oh, it depends on how long it would be going on.
Can I say the organisation? Because this is far away from the VBA and Army cases because of what occurred as the ultimate result of it. But if in this case, if the person who was being subjected to it died, I think that we'd see reckless endangerment.
You reckon? I don't know if WorkSafe would take that step yet, the current thing, because a lot of it was tied to what is happening in her own personal life. And yes, Naomi... Was it Naomi?
Yeah,
no, Sarah. Sarah was exacerbating, but I think they'd want to see a bit more to meet the reckless
I think
test.
it's close though, because what they'd see is, I understand it shows a lack of empathy, but it was a bit more than that. It was carelessness.
Yeah, but what I'm saying is I think the current regulator, just with the cases and the charges they're putting up, they're not yet taking that step for
they're not as
charging
far
those
as
people.
that. But I reckon it's up there. Okay, was there discrimination or general protections? Yes, there is. Yes, there's an identification of I'm struggling, I think to a stage where her own behaviour and Sarah's knowledge of her behaviour is that it was a mental health issue.
Yeah.
Not a defined one, or not one that's diagnosed, but doesn't need to be.
But also a right to a safe workplace as well.
Yeah, and that's Burke and Suncorp. So there you go, guys. That was fun. Good to be here. I'm a bit tired, Nina. God, I tell you what.
You say this
not as tired
week.
as Joy, who's sitting down there staring at the camera trying to stay awake, but
thanks for joining us though. And give us a thumbs up.
Yeah, could you do that? That'd be good. Cheers.
Bye.
Bye-bye.